1999, referencing the United States Supreme Court case of Hill. Again, the Second Circuit upheld and their phrase was zone of separation, recognizing the Madsen test. That's why I said during the trial, maybe inappropriately while the evidence was going on, that's what the heart of this case is, the Madsen case. And that is whether the challenge provisions of an injunction burden no more speech than necessary to serve a significant governmental interest. There's the balance. There's the seesaw. No more restriction on speech than necessary to serve the other interest, the significant governmental interest. I have not had a chance to go through the 23-page decision of the NAACP, Your Honor. Last night, I was putting this together. I will address the Claiborne case, but it certainly sounds to me as though that case decided in 1982, and my quick perusal suggests that this goes back to a very dark time in our recent history, and it is not precedent for the case in front of you. It deals with racial discrimination and the like. But I will address that in a follow-up memo. So, in conclusion, I want to emphasize that the City of Keene is an employer. The City of Keene is a corporation. The law in New Hampshire recognizes that municipalities are treated the same as other corporations, other employers, other persons under the law. There is no difference. And if there are vested rights in the private corporate employers, there are such rights in public corporate employers. I think it would be inappropriate for this court to find as a matter of law that there are no such interests that the city has in its employment relationships with its employees. I guess I'd like to reserve a couple of minutes in rebuttal to whatever else needs to be argued at this point.
Not a problem. Attorney Meyer. Your Honor, along the lines of the couple minutes of rebuttal, I don't want to get into a tit for tat, but I do want to spend about 2 minutes just responding or adding to a couple of questions that Bauer raised. First of all, he says it's a fundamental question, does the city have a right to an employment relationship? I wouldn't use the word right, but I wouldn't deny the fact that the city has a contractual relationship with its employees. So that's not a controversy in the state. The issue is whether the contractual relationship with the employee enables it to then bring this interference in contractual relations claim against a political organization motivated by political First Amendment concerns. Secondly, he raises the specter of the city being sued by its employees for a hostile work environment. The fact is, an employer can't be sued by employees for a hostile work environment. Even if a hostile work environment by itself were illegal, it's not. You can't sue for it because the workers' comp law. So there would be no conceivable claim there. I'm not saying that an employer, any employer, including a state, shouldn't try to protect its employees. One of the remarkable facts about the record here is how little effort was made to provide genuine protection. But certainly, there can be no claim by the employees for a hostile work environment against the employer. Thirdly, Attorney Bauer repeatedly relied on the McCollum case, which is the most recent First Circuit abortion case, upholding a 35-foot fixed buffer zone. The remarkable fact, Your Honor, about that reliance is that the U.S. Supreme Court took cert on that case. statistically, when the U.S. Supreme Court takes cert in a case, 70% of the time it reverses. So to rely on that opinion, the heavy reliance on that opinion, where the Supreme Court has already given a strong signal that it's not going to be upheld, seems to me significant. But the point about the McCollum case is interesting. Is the McCollum case really went no further than prior U.S. Supreme Court cases. So the fact that the current U.S. Supreme Court has chosen to review it, I think is a suggestion, if anything, that the court is going to be more restrictive in terms of dealing with, less likely to uphold buffer zone type restrictions. The final point that this was a question about the right to be left alone that Attorney Bauer invoked in broad terms. Whether there is a right to be left alone and in what context exists is extremely controversial. Most recently, the New Hampshire Supreme Court addressed that in the case of Doyle versus Department of Resource and Economic Development, which actually comes from this part of the state. My client, John Doyle, was dressed up in a guerrilla outfit on Mount Monadnock, and hikers were complaining that he was disturbing their solitude. And the court said, and the state said, we're standing up for the right of hikers to be left alone. The state basically said, New Hampshire Supreme Court said, there's a lot of doubt whether there is such a right. We're not going to move on to this case, but certainly Doyle doesn't stand for it. And even if there is a right to be left alone, there's absolutely no precedent for saying that government employees have a right to be left alone. There's a qualitative difference between government employees on the one hand versus private citizens on the other. Your Honor, in terms of the specific issues, in terms of the preliminary injunction in this case, Attorney Bauer made an argument that the jury's going to have to decide ultimately whether or not there was a violation of the court if the court exists. Again, a strange observation, given the fact this is an action in equity. The plaintiff has not sought a jury trial. So unless and until the court consolidates the cases and finds a right to a jury trial, this is not going to be determination by jury, but determination by the court. In terms of the facts of this case, again, the court's heard 2.5 days, taking extensive notes. I'm not going to spend the court's time trying to summarize it. I would say to make two observations. First of all, there was really more agreement between the witnesses than disagreement, notwithstanding all the theatrics surrounding the case. Secondly, I need to make 3 points. Secondly, I think that in some ways the video evidence here is more reliable than the recollection of individual witnesses. And the videos she presented, one of them presented Mr. Colson, who was supposed to be the principal source of the enforcement officer complaints, demonstrating remarkable restraint and composure when confronted by a very angry and abusive counter-demonstrator. Then there were 2 videos by one of the 3 party enforcement officers, Ms. McDermott, again showing that she was engaging in very civil and sometimes humorous exchanges with the defendants. And thirdly, a video of Mr. Gibbets showing that he was basically the one that was invading the space of the videographer by deliberately turning around and moving towards the videographer rather than vice versa. The third fact I just want to point out is there's been testimony that the city retained this Mr. Thomas specifically to sort of monitor the demonstrators and prepared 30-odd hours of tape. Beyond that, there's hundreds of hours of tape on the internet. With all that material, that the only tape that the city found halfway incriminating was that one 20-minute, 15-minute tape of Mr. Colson videotaping Mr. Gibbets, and it speaks for itself. I mean, if if in fact there was this, any significant level of misbehavior occurring on behalf of the defendants, I think there would be some videographic evidence of that, which there is not. I'm not claiming here, and I don't think anybody's going to claim on the defense side that they're perfect, and I think you heard some of the hard enforcement officers acknowledge that they weren't perfect either. But the overwhelming weight of the testimony in this case is that this is sincere political activism with no violence, and any instances of incivility were greatly outweighed by instances of consideration and accommodation and acknowledgement without any interference or involvement by the city or any need for any type of constructive relief. So again, I'll leave it to the court beyond that to weigh the facts here. I would point out, though, on the preliminary injunction, two final points. First of all, it's clear under equity we're supposed to do irreparable harm. The city's now brought another lawsuit claiming that these damages can all be assessed based on money damages. If that's the case, as their witness claims, then surely there's no basis here for injunctive. And again, I would note that the claim here is not by the parking enforcement, it's purely by the city. It's purely by the city for its financial losses. So no evidence of any irreparable harm that would require injunctive relief. And finally, one of the factors that the court is supposed to weigh heavily in granting or not granting injunctive relief is public interest. And the issue in terms of public interest here is not my client group. It's the precedent that would be set by granting of injunction as it applies to any group of political activists within this city or indeed within any city in the state. And I think that the importance of maintaining the principle of free expression of political activism greatly trumps any claim for either group on behalf of the city. Now, in terms of, I want to lastly address the issue of the remedy that's been proposed here. And I would suggest, first of all, that what we're talking about here is, this is a remedy. This whole case, when you look at the remedy, becomes a case of sound and fury signifying nothing. Because that's what the remedy is, the proposed remedy is, it's nothing. Now this, again, the remedy has really, the proposed remedy by the city has evolved and indeed transformed. It started off with a floating absolute footage restriction, which once we pointed out was clearly against U.S. Supreme Court precedent. The city eventually dropped it. In the abortion cases, you're dealing with an incredibly vulnerable population. Women seeking abortion services, medical patients, privacy issues, private citizens, and you're dealing with extremely hot-button issue, extremely angry protesters, instances of violence, vandalism, heated arguments. So a much more heated scenario than anything suggested in this case. Nevertheless, the U.S. Supreme Court has basically said no to any type of floating zone, and only permitted, limited fixed zone. And the most recent case, Collin case, was permitted by the First Circuit, the Supreme Court said we can take another look at that issue. So certainly, in the abortion context, the Supreme Court hasn't done this balancing of interests that Attorney Bauer proposes. It's been very much the interests that have been protected, and very much the interests of the demonstrators. And in this case, not only do we not have a vulnerable population of medical patients, we don't even public citizens, public employees. And by definition, public employees are clothed with public authority, and there's no precedent at all that I'm aware of that they're somehow entitled to special protection under the law. Now, but getting to the specific language of this proposed agreement, one of the, is the court have a copy of that?
Yeah.
Notwithstanding all the argument made by the city This proposal contains no limit on video taking from any distance. It contains no limit on speech from any distance except for taunting, which is not allowed. Whatever that is, not defined. It contains no limit on persuading parking enforcement officers from resigning. Even if that's the ostensible basis for this case in the first place, there's nothing in here that in any way limits the right of defendants or anybody else to try to persuade parking enforcement officers to resign. So Attorney Bauer suggested that somehow that there's a 30-foot restriction on some type of activity. But the activities that are restricted are the touching, taunting, obstructing, detaining, hindering, blocking, intimidating, or harassing. Those are the only things that are restricted. So, you know, you could say, well, this is such a narrow limitation, what do you care? The answer is that these terms are so vague that if the court issued an injunction, anything like this injunction, we'd be back in court in 24 hours. Not because of bad faith, not because we're quibbling over how far away 30 feet is, but because the basic concepts here of harassment or intimidation are completely in dispute. I mean, for example, the city psychologist testified that any videotaping was intimidation.